During the 1948 Nakba, 800,000 Palestinians, or 85% of the indigenous population, fled or were expelled because of the war. Those Palestinians left lands, orchards, homes, furniture, and all their belongings behind. Initially, Israel controlled these properties through multiple committees and emergency regulations, until the Israeli government enacted the Absentee Property Law in 1950 in order to ensure its permanent possession of Palestinian property belonging to internal and external Palestinian refugees. This law created a new legal status, an absentee and a custodian who is in charge of property deemed absentee property. According to the law, an absentee includes any person who on or after November 29, 1947 was a citizen of one of the Arab countries at war with Israel, namely Jordan, Syria, Iraq, Egypt, Lebanon, Saudi Arabia, or Yemen. In any of the aforementioned countries or territories not part of the State of Israel, namely the West Bank and the Gaza Strip. In any place other than their habitual residence, even if they are still within Israeli-occupied territory. This sweeping definition of an absentee included almost all Palestinians that vacated their homes because of the Nakba, regardless whether they returned or not, allowing Israel to confiscate their lands and properties, movable and immovable, and even seizing the property of Palestinians who reside in an Israel-occupied territory and left their home, even for one day, and then returned. This legal transformation of the appropriated Palestinian lands of 1948 was the reason for the Jewish domination of Israel's sovereign territory. In 1967, Israel occupied the West Bank and the Gaza Strip and immediately annexed East Jerusalem and applied its sovereignty and jurisdiction over it in violation of international law. At the beginning, Israel refrained from implementing the absentee property law extensively in East Jerusalem. Nonetheless, it was applied, and many Jerusalemites who resided elsewhere lost their properties because of its implementation. The absence of Palestinians is merely technical, especially the Jerusalemites who own properties and reside in the West Bank, who became absentees because of Israel's occupation and annexation of East Jerusalem. During the 80s and 90s, the old city of Jerusalem and Silwan neighborhood witnessed an increase in the transfer of Palestinian properties to the hands of Jewish settler organizations. Dozens of Palestinian homes were transferred to these settler associations through the absentee law, and millions of shekels were invested through generous state funding in order to complete the transfer. In 2018, Israel decided to carry out a land title settlement for the lands in occupied East Jerusalem in violation of international law. Any block of land in East Jerusalem that will go through the land title settlement and that is legally owned by a Palestinian who is considered an absentee will be expropriated to the permanent possession of Israel. Israel must immediately cease the application of its domestic laws on occupied East Jerusalem, and in particular, the outrageous absentee property law, and must immediately cease the land title settlement on Palestinian lands. Read more about Jerusalem and call on your state representatives to take immediate action to stop the crime of forcible transfer of Palestinians from Jerusalem.